Let's begin with the next question. What is statutory analysis and why is it important? Statutory analysis involves interpreting and applying statutes, that is, laws, to understand their meaning, scope, and implications. It is essential for ensuring compliance with legal obligations, resolving ambiguities in legislative text, applying laws effectively to real world scenarios. For example, analyzing the Information Technology Act 2000 helps stakeholders understand its provisions on cybersecurity, e commerce, and digital signatures. Next, what are the objectives of the Information Technology Act of 2000? The IT Act 2000 aims to provide legal recognition to electronic transactions and digital signatures, facilitate e-commerce and e-governance by ensuring secure online communication, prevent cybercrime and ensure cybersecurity, and establish mechanisms for investigating and prosecuting offences under the Act. For instance, Section 5 of the IT Act grants legal validity to digital signatures, enabling paperless transactions. How does the IT Act address cybercrimes? The IT Act addresses cybercrime through several provisions. Section 66 punishes acts like hacking, spreading viruses, and causing damages to the computer system. Section 66A, which has now been struck down by Supreme Court, earlier criminalized offensive online content but was deemed unconstitutional in Shreya Singhal versus Union of India 2015. Section 66C penalizes identity theft and phishing. Section 72 protects privacy by penalizing unauthorized access to personal data. These provisions aim to deter malicious activities while balancing individual freedoms. Next, what challenges arise in implementing the IT Act of 2000? The main challenges are technological advancement, because of which the legal framework is always behind the rapid changes in the technology, thus creating gaps in coverage. Jurisdictional issues. The cross-border cybercrimes complicate enforcement due to differing national laws. Awareness gaps. Many individuals and organizations lack knowledge about their rights and responsibilities under the Act. Enforcement capacity. Limited resources and expertise hinder effective investigation and prosecution. For example, tracing anonymous hackers operating from foreign servers remains a significant challenge. How do courts interpret ambiguous provisions in the IT Act? Court uses principles of statutory interpretation to resolve ambiguity. This is the normal approach that a court would take regardless of which act it is. So first is the literal rule, that is interpreting words based on their plain meaning unless there is ambiguity or absurdity arises. Golden rule, modifying the literal interpretation to avoid irrational outcomes. Mischief rule. Focusing on the problem the statute seeks to address. Purposive approach, considering the broader purpose of the legislation. In Shreya Singhal versus Union of India 2015, the court struck down Section 66A, holding that vague terms like annoyance violated freedom of speech. Next, discuss the significance of the amendment to the IT Act in 2008. The 2008 amendment strengthened the IT Act by introducing stricter penalties for cybercrimes such as imprisonment and fines, establishing the role of intermediaries, that is, social media platforms, in regulating user generated content, addressing emerging issues like child pornography or cyber terrorism, and creating institutions like the Cyber Appellate Tribunal for dispute resolution. For example, Section 69A empowers the government to block websites threatening national security. How does the IT Act balance innovation with regulation? The IT Act promotes innovation while imposing safeguards, encouraging innovation. Legal recognition of electronic records and digital signatures fosters technological adoption. Regulating risks. Provisions on cybersecurity and data protection, mitigating risks associated with technology misuse. Adapting to change. Amendments ensure the Act remains relevant amid evolving changes. For instance, the Act enables startups to leverage digital tools while holding them accountable for safeguarding user data. So, this is how the IT Act balances innovation with regulation, that is, encouraging innovation, regulating risk, and adapting to changes. What role do intermediaries play under the IT Act? This seems to be an important question. Intermediaries, example ISPs, that is, Internet Service Providers, social media platforms, act as conduits, channels, that is, for information but face obligation under the Act. First one is safe harbor protection. Section 79 provides immunity if intermediaries comply with due diligence requirements. Content takedown. They must remove unlawful content upon receiving government orders or court directives. Liability. Failure to comply may result in penalties or loss of safe harbor protection. For example, WhatsApp and Facebook have faced scrutiny over misinformation and hate speech under these provisions. How, how has the IT Act impacted e-governance in India? The IT Act has transformed e-governance by enabling online filing of tax returns, passport applications, and other services. This is also an important question. Reducing paperwork and enhancing transparency through digital documentation. Streamlining processes using Aadhaar-based authentication and digital signatures. Fourth, promoting financial inclusion through initiatives like UPI, Unified Payments Interface. For instance, the Digital India campaign relies heavily on the IT Act's framework to deliver citizen-centric services. Next, what lessons can be learned from the implementation of the IT Act? First, it is a dynamic legislation, that is, laws must evolve continuously to keep pace with technological advancements. Second, balancing rights and security. Overly restrictive measures can infringe on the fundamental freedoms as seen in Shreya Singhal. Third, stakeholder engagement. Governments should involve industry, civil society, and experts in drafting regulations. Fourth, capacity building. Strengthening enforcement agencies and public awareness is critical for success. For example, the backlash against Section 66A highlights the importance of crafting precise, constitutionally sound laws. What is justice in the legal context? Justice refers to the fair and equitable treatment of individuals in accordance with moral, ethical, or legal principles. What is justice in the legal context? This is an important question. Justice refers to the fair and equitable treatment of individuals in accordance with moral, ethical, or legal principles. It ensures protection of rights, resolution of disputes, punishment for wrongdoing, and restoration of balance when harm occurs. For example, criminal justice aims to punish offenders while civil justice seeks to compensate victims. Differentiate between bar and bench. Bar refers to the collective body of lawyers qualified to practice law in a jurisdiction. They represent clients and advocate in courts. Bench refers to judges collectively or individually who preside over courts. The term symbolizes judicial authority. For instance, during a trial, the bar presents arguments while the bench evaluates evidence and delivers judgments. Explain the relationship between duty and right. Right is a legal entitlement that one can enforce against others or the state. That is, right to free speech is one of the right. Duty. Duty is an obligation imposed by law to respect others' rights. Example, duty not to defame. For example, the right to life imposes a duty on the state to protect citizens from harm. What constitutes a wrong in law and what remedies are available? A wrong is a violation of a legal right or a breach of duty recognized by law. Remedies depend on the type of wrong. That is, civil wrong, which includes torts, compensation, injunctions, or specific performance. Criminal wrongs include punishments like imprisonment, fines, or community service. For instance, a breach of contract may result in monetary compensation, while theft leads to criminal penalties. Distinguish between fact and jurisdiction. I'm just going through the reading of this because I don't find that I need to explain much into detail about these topics. Where required, I'll go into more detail. Distinguish between fact and jurisdiction. Fact is a circumstance, an event, or a detail relevant to a legal dispute. Example, the date of an accident is a fact. Jurisdiction. The authority granted to a court or a tribunal to hear and decide cases within a defined area or a subject matter is a jurisdiction. For example, a court must first establish its jurisdiction before examining the facts of a case. Who qualifies as a person under the law? A person under the law includes natural persons, that is, human beings with legal rights and obligations, and legal persons like entities, corporations, partnerships, trusts, endowed with legal personality. For instance, a company can sue or be sued as a legal person. Define offense, bail, and damage. Offense is an act or omission of an act punishable by law as a violation of societal norms, that is, theft, murder, etc. Bail. Bail is a temporary release of an accused person awaiting trial, often subject to conditions like surety or bond. Damage. Damage is a loss or a harm suffered due to another's wrongful act for which compensation may be claimed. For example, vandalism is an offense. Bail allows pre-trial freedom and property destruction constitutes damage. What is the purpose of compensation in law? Compensation aims to restore a victim to their original position before the harm occurred. It is typically monetary and applies in civil cases like breach of contract, negligence causing injury or loss, property damage. For instance, if a car accident results in medical expenses, compensation covers those costs. Now, what happens during a trial? A trial is a formal examination of evidence and arguments presented by parties before a judge or a jury to determine guilt or liability. Key stages include opening statements, that is, parties outline their case. Second, evidence presentation, witnesses testify and documents are submitted. Third, closing arguments, summarizing key points. And fourth, judgment. The court announces its decision. For example, in a criminal trial, the prosecution must prove guilt beyond a reasonable doubt. What is a petition and how is it used in law? A petition is a formal written request submitted to a court or authority seeking relief, intervention, or enforcement of a right. The different type of petitions include writ petitions, bail petitions, and public interest litigations. Writ petitions include habeas corpus, mandamus, and other writ petitions that we discussed in the earlier questions. They seek constitutional remedies. Bail petitions request temporary release of an accused. Public interest litigations, PIL, raises issues affecting public welfare. For instance, filing a PIL can address environmental violations affecting communities. How do legal concepts like right and remedy interact? Right and remedies are interconnected. Every legal right implies a corresponding remedy if violated. Remedies ensure enforcement of rights through actions like compensation or injunctions. For example, the right to privacy entitles individuals to seek damages if their personal data is misused. Next, why is jurisdiction critical in resolving disputes? Jurisdiction ensures proper allocation of cases to competent courts, avoidance of conflicting decisions, and adherence to procedural rules. For instance, a family court lacks jurisdiction over criminal matters, which must be heard in criminal courts. Next, how does bail function as a legal safeguard? Bail serves as a safeguard by presuming innocence until proven guilty. This is important, allowing accused persons to prepare their defense without undue confinement and preventing overcrowding in jails. However, bail may be denied in serious offenses like terrorism or murder. What distinguishes damage from compensation? Damage refers to the actual harm or loss suffered. Example, physical injury, property destruction. Whereas compensation refers to the monetary award provided to redress the damage. For example, a damaged car represents damage, while the repair cost paid to the owner is the compensation. What is a head note in a judgment and how does it aid legal research? A head note is a concise summary at the beginning of a reported case that highlights key points, including facts of the case, issues raised, decision of the court, and ratio decidendi, that is the binding principle. It aids legal research by providing quick insights into the case's relevance without reading the entire judgment. For example, head note in Maneka Gandhi versus Union of India emphasizes the expansion of Article 21 to include procedural fairness and following due process of law. So, the head note consists of facts of the case, issues raised, decision of the court, and ratio decidendi, that is the binding principle. Next, explain the abbreviations commonly used in judgments. Abbreviations streamline references to statutes, regulations, and authorities. For example, SC stands for Supreme Court, HC stands for High Court, AIR stands for All India Reporter, SCC stands for Supreme Court Cases, CRPC stands for Criminal Procedure Code, IPC stands for Indian Penal Code. For instance, Maneka Gandhi versus Union of India is cited as AIR 1978 SC 597 or in bracket 1978 to SCC 248. Next, how do courts determine jurisdiction in landmark cases like Maneka Gandhi? Jurisdiction refers to a court's authority to hear and decide a case. In Maneka Gandhi, the Supreme Court exercised its appellate jurisdiction under Article 136 of the Constitution. The case involved fundamental rights under Article 21. The petitioner challenged the confiscation of her passport without reasons, invoking judicial review. The court's jurisdiction ensured adherence to constitutional principles and due process. We should also learn about appellate jurisdiction, what it means under Article 136 of the Constitution. Next, what we have to understand is what is appellate jurisdiction. So, appellate jurisdiction refers to the power of a higher court to review, revise, or reverse the decision of a lower court, which means when someone is not satisfied with a judgment from a lower court, they can appeal to a higher court. This process is known as appellate jurisdiction or covered under appellate jurisdiction. The key points of appellate jurisdiction is that the higher court can hear the appeal and check whether the lower court made any legal or factual error. The Supreme Court and High Courts in India have appellate jurisdictions, only they have. Appellate jurisdiction can be over civil matter, criminal, constitutional, or administrative matters. Let's take an example. Suppose a person is convicted of a theft by Sessions Court. They can appeal to the High Court to review the conviction. If the High Court also upholds it, the person may file a special leave petition in the Supreme Court under Article 136. Alright, so the types of appellate jurisdiction in India are under the courts of Supreme Court and High Courts. That is, Supreme Court can hear appeals in constitutional, civil and criminal matters, and High Courts can hear appeals from district and subordinate courts. Okay, now let's move on to the next question. Who were the judges in Maneka Gandhi versus Union of India and what was their contribution? The bench comprised 5 judges: Chief Justice V.Y. Chandrachud, Justices P.N. Bhagwati, A.C. Gupta, N.L. Antwalia and Fali Nariman. Their unanimous decision expanded the interpretation of Article 21, emphasizing that any procedure depriving life or personal liberty must be fair, just and reasonable. This marked a shift from the restrictive procedure established by law to the broader due process doctrine, which means, I've already explained this in the earlier video, here I'll explain again. the difference or the distinction between procedure established by law and due process of law. So what is procedure established by law? These are the rules and procedure which are in the acts or in the law passed by the legislative. Now, the due process doctrine, which was followed in the US, and through this landmark case of Menka Gandhi versus Union of India, was established to be followed in India also. This due process meant that in this particular matter, when the passport was impounded, was taken away from Menka Gandhi, she was not given the reason for that. And the due process that needs to be followed, that is, the process is that the reason has to be given for impounding of the passport, that is, taking away of the passport. The person needs to be heard or has the right to be heard. His justification needs to be heard, and that process needs to be followed. So that is why this was considered as a landmark case. Discuss the role of statutes and international conventions in Menka Gandhi. In Menka Gandhi, the court interpreted statutes, that is the Passport Act. Statutes are laws. So in this case, statute was the Passport Act of 1967, which authorized passport impoundment but lacked clarity on procedural safeguards, which means there was no safeguards as to giving what was the reason for impounding the passport, or for allowing the person to be heard, or allowing them to give justification for whatever matter. International conventions, while not directly applicable, principles like the Universal Declaration of Human Rights influenced the court's emphasis on fairness and justice. This integration of domestic and international norms reinforce the need for harmonizing laws with global human rights standards. Let us also go into a little bit detail on this side also of this video into the due process of law. Alright, let's understand the due process of law in detail. A due process of law means that no person shall be deprived of life, liberty or property without a fair, just and reasonable legal procedure. It ensures that laws are not only properly followed, that is the procedural fairness which was followed in India earlier, but also that the laws themselves are just and not arbitrary, that is substantive fairness. That is, not only the procedure has to be followed, but the laws itself needs to be fair and just. The two types of due process are procedural due process, which focuses on how the law is applied, requires fair procedures like right to notice. The notice needs to be given to the party, right to a hearing, he needs to be heard, a right to a lawyer, he has a right to have a lawyer present, and an impartial trial. Whereas substantive due process focuses on what the law says. Earlier, India used to follow only substantive due process. But after this case law, we started following due process of law as well as. That is the procedural due process and substantive due process both. So these protect individuals from unjust laws even if the procedure is followed. The law itself must be reasonable, non-arbitrary and just. So this process was developed in United States. It guarantees protection against unjust laws and government's abuse of power. So the government just cannot impound the passport as it feels. It has to follow certain procedures or due process of law. So originally, this is important, originally the Indian Constitution Article 21 followed procedure established by law, which meant any procedure laid down by the legislature, whether just, whether proper, fair or not. So this was wrong. Thereafter, after the landmark case of Menka Gandhi versus Union of India, the Supreme Court expanded this interpretation to include Article 21, due process of law, meaning that the procedure must be fair, just and reasonable. Let's move on to the next question. How did bylaws, rules, and regulations feature in Ratlam Municipality versus Vardi Chand? In Ratlam Municipality, the court addressed bylaws and rules and regulations. So, in the bylaws, local municipal regulations governing public health and sanitation laws were examined. Under rules and regulations, frameworks for implementing statutory duties under the Municipalities Act was addressed. The court held municipalities accountable for enforcing these laws to prevent nuisances like open drains and unsanitary conditions, ensuring compliance with public welfare obligations. Next, let's look at the next one. What notice or notifications were relevant in Ratlam municipality? The case involved notices issued by citizens, complaints about public nuisances filed with local authorities, and orders directing the municipality to take immediate action. These documents highlighted the failure of the administrative bodies to address grievances, prompting judicial intervention. So this case law is Ratlam Municipality, Ratlam Municipality versus Vardi Chand. How did the Supreme Court interpret Article 21 in Maneka Gandhi? The court redefined Article 21, holding that it guarantees more than mere physical existence. It encompasses dignity, liberty, and quality of life. Procedural safeguards must align with principles of natural justice. So, this is the interpretation of Article 21 by the Supreme Court, which expanded the definition of Article 21. This interpretation set a precedent for protecting individual rights against arbitrary state actions. Next, what significance does Ratlam municipality hold for environmental jurisprudence? Ratlam municipality versus Vardi Chand is significant because first, it recognized the judiciary's role in enforcing public health and sanitation laws. Second, it emphasized accountability of local bodies towards citizens' welfare. And third, it laid the groundwork for future environmental litigation by addressing issues like pollution and unhygienic living conditions. This case demonstrated how courts can compel authorities to fulfill statutory duties for societal benefit. Next, how do these judgments influence modern legal practices? This is also an important question. Both cases have enduring impacts. In Maneka Gandhi, it reinforced the importance of procedural fairness and safeguards against executive overreach. In Ratlam municipality, it highlighted the judiciary's proactive role in ensuring governance accountability. Lawyers and judges frequently cite these precedents to argue cases involving fundamental rights, administrative responsibilities, and public interest. Next, what lessons can be learned from the interplay of statutes, rules, and judicial decisions in these cases? So, few of the key lessons include: first, statutory gaps often necessitate judicial intervention to uphold justice. That is, the judiciary has to intervene to reduce the statutory gaps, that is, ambiguity in the law or the confusion created by contradicting laws. This intervention is required to uphold fairness and justice. Second, rules and regulations must align with constitutional principles to ensure effective implementation. So all rules and regulations have to be as per the constitution. It cannot go against the constitutional principles. Third, public participation through notices and complaints plays a vital role in holding authorities accountable. For example, both cases underscored the judiciary's responsibility to bridge legislative shortcomings and protect citizens' interests. Next, what were the charges against Bal Gangadhar Tilak in his trials? Bal Gangadhar Tilak was charged under IPC section 124A, which is the sedition law, for inciting dissatisfaction against the British government. Section 153A of the IPC, that is promoting enmity between different groups on grounds of religion, race, place of birth, residence, language, etc. These charges stemmed from his writings in newspapers like Kesari and Maratha, which criticized colonial policies and inspired nationalist sentiments. So, two sections to remember here for charges against Bal Gangadhar Tilak in his trial is the sedition, which is covered under section 124A, and promoting enmity under section 153A, both of the IPC, Indian Penal Code, 124A and 153A. So these charges were for the writings that he had published in newspapers like Kesari and Maratha. What were the key events leading to Tilak's first trial in 1897? The first trial arose after the assassination of a British officer, W.C. Rand, by the Chapekar brothers. The prosecution alleged that Tilak's articles glorified acts of violence and incited rebellion. Key points include: Tilak published articles criticizing the plague measures imposed by the British. He wrote about Shivaji's legacy, portraying him as a symbol of resistance against tyranny. So these were the two key points which were cited as inciting violence and rebellion against the British government, and therefore the sedition law and incite enmity, promoting enmity between different groups, that is both the sections of 124A and 153A. The court convicted Tilak, sentencing him to 18 months of rigorous imprisonment. This trial marked the beginning of Tilak's image as a nationalist leader opposing colonial rule. Next, how did the second trial in 1908 differ from the first? In the second trial, Tilak faced charges for publishing articles perceived as justifying revolutionary activities following the Elypon bomb case. So, in the second trial, Tilak faced charges for publishing articles perceived as justifying revolutionary activities following the Elypore bomb case. The differences were: focus on nationalism. The prosecution argued that Tilak's writings encouraged violence against the British. Second was international attention. The trial drew global scrutiny with figures like Max Weber defending Tilak. The outcome was that Tilak was sentenced to 6 years of transportation to Mandalay, Burma. This trial highlighted the growing tension between colonial authorities and Indian nationalists. So there were two different years in which Bal Gangadhar Tilak was the trial had happened and he was convicted. First one was in 1897 and the second was in 1908. What arguments did Tilak present in his defense during these trials? Tilak defended himself by arguing first that he had a freedom of speech, that is, his writings aimed to educate the public and critique policies, not incite violence. Metaphorical language. Articles used historical references metaphorically to inspire patriotism, not sedition. Lack of direct evidence. Prosecution failed to prove a direct link between his writings and violent acts. Despite these defenses, colonial courts interpreted his words through a lens of suspicion and hostility. Next, how did Section 124A, sedition, played a central role in Tilak's trials? Section 124A criminalizes acts intended to excite or attempt to excite disaffection toward the government. In Tilak's case, the British used it to suppress dissent and curb nationalist movements. Courts interpreted disaffection broadly, encompassing any criticism perceived as undermining authority. Tilak's conviction under this section became symbolic of the struggle for free speech in colonial India. So the section is 124A of the IPC. His trials exposed the draconian nature of sedition laws, which continue to be debated in modern India. What impact did Tilak's trials have on Indian nationalism? Tilak's trials had profound impacts on the freedom movement. First, it was a symbol of resistance. Tilak became a martyr-like figure, inspiring millions to join the struggle. Second, it created awareness of colonial oppression. His imprisonment highlighted the repressive nature of British laws. And third, it set legal precedents, which means the trials set benchmarks for interpreting sedition and free speech, influencing future cases. For example, Tilak's slogan, "Swaraj is my birthright and I shall have it," galvanized mass support for self-rule. How did the judiciary handle evidence in Tilak's trials? The judiciary relied on writings as evidence. Articles and editorials from Tilak's newspapers were cited as proof of sedition. Testimonies. Witnesses, often British officials testified that Tilak's words incited violence. And interpretation bias. Courts interpreted metaphors and allegories in his writings as calls for rebellion. Critics argue that the lack of concrete evidence reflected the colonial judiciary's bias against Indian nationalists. Next, what lessons can modern legal systems learn from Tilak's trials? Key lessons include balancing free speech and security, that is, laws like sedition must be applied cautiously to avoid stifling legitimate dissent. Second, judicial independence. Courts should remain impartial even amid political pressures. Third, public perceptions. Trials of high-profile individuals shape public opinion and trust in the justice system. For instance, debates over Section 124A today echo concerns raised during Tilak's era about its misuse. Next, how did Tilak's trials influence the interpretation of Section 153A? Section 153A penalizes promoting enmity between the groups. In Tilak's trials, prosecutors argued his writings fostered communal tensions by framing colonial rules as divisive. So he stated that the rules and laws of the Britishers were divisive in nature. That is, they divided people based on caste and courts interpreted this provision expensively, targeting speeches or publications deemed inflammatory. Critics viewed this as an attempt to silence voices advocating unity against British oppression. These interpretations influenced later cases involving hate speech and communal harmony. Next, how does Tilak's legacy resonate in contemporary discussions on free speech? Tilak's legacy underscores the ongoing tension between state authority and individual rights. First is the free speech advocacy. Activists cite his trials to oppose restrictions on dissent, sedition law debates, calls to reform or repeal Section 124A reference Tilak's persecution, and nationalist symbolism. His courage in defending principles inspires modern movements for justice. For example, recent cases involving journalists and activists charged under sedition laws evoke parallels with Tilak's struggles. Tilak's legacy underscores the ongoing tension between state authority and individual rights. So we completed this. There were three things that resonates in contemporary discussions on free speech. That is, whenever we talk about free speech in today's age, we refer to Tilak's legacy. That is, we speak about free speech, we speak about sedition law and nationalist symbolisms. Next, what was the Nanavati trial and why is it considered a landmark case? The Nanavati trial refers to the high-profile case of Commander Kavas Manekshaw Nanavati, an Indian naval officer accused of murdering his wife Sylvia's lover Prem Ahuja in 1959. It is considered a landmark case because it marked the end of jury trials in India due to perceived bias. So this is the key one. It marked the end of jury trials in India due to perceived bias. It highlighted tensions between public sentiment and judicial impartiality. And third, it set precedents in criminal law regarding provocation and premeditation. The trial captivated the nation, blending elements of crime, passion, and morality. What were the key facts of the Nanavati case? The key facts included Nanavati discovered his wife's affair with Prem Ahuja, a businessman. On September 27, 1959, Nanavati confronted Ahuja with a revolver, leading to Ahuja's death. Nanavati argued the killing was accidental, claiming Ahuja had insulted him and grabbed the gun during their altercation. The murder was premeditated. This was the prosecution's argument, that the murder was premeditated as Nanavati had time to plan after learning of the affair. These facts fueled debates about whether the act was an impulsive reaction or a calculated crime. How did the jury initially rule in the Nanavati trial? The jury initially acquitted Nanavati of murder, ruling the killing as an act of grave and sudden provocation. Key factors included public sympathy for Nanavati as a betrayed husband. Second, medical media portrayal of the case as a moral issue rather than a legal one. And third, emotional appeals during the trial that swayed jurors. However, the Bombay High Court overturned this verdict, convicting Nanavati of culpable homicide not amounting to murder. This is a keyword, culpable homicide not amounting to murder. We'll understand what is culpable homicide not amounting to murder. Okay, so let's understand what is culpable homicide, section 299 of the IPC. Definition: culpable homicide means causing death with the intention of causing death. There is an intention of causing death, or with the intention of causing such bodily injury that is likely to cause death, or with the knowledge that the act is likely to cause death. It is the generic term. All murders are capable homicide, but not all culpable homicides are murder. So I'll just revise this. All murders are culpable homicides, but not all culpable homicides are murders. So all culpable homicides are not murders, which means that there is a death, causing death or bodily injury that is likely to cause death. Okay, so basically all murders are culpable homicide, but not all culpable homicides are murders. Now, let us look at culpable homicide not amounting to murder, which is section 304 of the IPC. This is a less serious offense than murder, where intention or knowledge is present, but the act doesn't fulfill all the conditions of murder under section 300 of the IPC, or the case falls under the exceptions to section 300. Examples of culpable homicide not amounting to murder. Example 1. Sudden fight. A heated argument in a village leads to a fight and one person dies. No prior intention was there, or no planning was there for the murder or for the death. Second example is grave provocation. A husband returns home and sees his wife in an adulterous situation. In the heat of passion, he attacks and causes death. Third example, excessive force in private defense. A person trying to defend themselves from an attacker uses more force than necessary, unintentionally causing death. So basically, culpable homicide not amounting to murder, the main key here is that there was no prior intent of causing death in culpable homicide not amounting to murder. And this falls under the section 304 of the IPC. What are the punishment under section 304? Section 304 of the IPC has two parts. One, act done with intention to cause death or injury likely to cause death. And the punishment is for life or up to 10 years and fine. So in the first part, the act was done with the intention to cause death. Means there was an intention that death should occur or an injury should occur which will likely cause death. And in the part 2, the act was done with knowledge but no intention. The knowledge was there that this act will cause death. This punishment for part 2 is imprisonment up to 10 years or fine or both. Now, let's go with the murder. Section 300 IPC. These exceptions reduce the murder. So if there was a murder, that is if a death was caused with an intent, to cause death, or with an intent, with an injury likely to cause death, then it will amount to murder. So there are certain exceptions which are like grave and sudden provocation, private defense, that is excess use of force, public servant acting in good faith, that is police, military, and so on, sudden fight, no premeditation, that there was no intention that during the fight there was a intent to cause death, and the consent of the victim above the age of 18 plus. Now let us look at few of the landmark cases quickly. K.M. Nanavati versus the state of Maharashtra, 1962. The case involved sudden provocation exception. Virsa Singh versus state of Punjab, 1958, helped distinguish between murder and culpable homicide. State of Andhra Pradesh versus Raya Varappu Punaya, 1976. Clear difference explained between section 299 and 300. So let's do a quick revision. Culpable homicide is genus and murder is species. If you had studied logic in the first sem, you would understand what is the difference between a genus and a species. I don't want to go into it right now. If it doesn't fit the murder definition or exceptions, apply it, it becomes culpable homicide not amounting to murder. Meaning, if there are the exceptions of the murder are not there, then it is a murder. Otherwise, if there are exceptions, it fits the exceptions, that is, the case fits the exception, then it amounts to culpable homicide not amounting to murder. Why did the Nanavati trial lead to the abolition of jury trials in India? The trial exposed flaws in the jury system. First was public influence. Media coverage and societal biases heavily influenced jurors' decisions. Jurors prioritized emotional narratives over legal principles, and the acquittal by the jury contradicted the evidence presented, raising concerns about fairness. As a result, the Indian legal system abolished jury trials, shifting to bench trials where judges decide cases based solely on evidence and law. Next, how did the defense argue grave and sudden provocation? The defense invoked Section 300 of the Indian Penal Code (IPC), which reduces murder to culpable homicide if the act resulted from grave and sudden provocation. So, for murder, it is life imprisonment, and for culpable homicide, it is 10 years plus fine. So, arguments included that Nanavati acted impulsively upon discovering his wife's infidelity. Ahuja's alleged insults and aggressive behavior triggered the confrontation. There was no premeditation, as Nanavati returned home immediately after confronting Ahuja. However, the prosecution countered that Nanavati had sufficient time to cool off and plan the killing, negating the provocation defense. What role did media play in shaping public opinion during the trial? The media, we just have to understand this. We don't need to remember this. This may come for a longer text also, in a long question answer format, or even in a very short format or short note. But the more we read, the more we understand, the better it is, the more we can write about it. The media played a pivotal role. Newspapers sensationalized the story, portraying Nanavati as a victim of betrayal and Ahuja as a villain. Public sentiment leaned towards sympathizing with Nanavati, viewing the case through a moral lens rather than a legal one. Media coverage undermined the impartiality of jurors who were influenced by societal pressures. This case demonstrated the risks of excessive media interference in judicial proceedings. So, what role did media play in shaping public opinion during the trial? This was the question. Next, what was the final judgment in Nanavati trial? The Bombay High Court overturned the jury's acquittal, convicting Nanavati of culpable homicide not amounting to murder under Section 304 of the IPC. Key points include: the court found no evidence of grave and sudden provocation. It ruled the killing was premeditated, as Nanavati had time to procure a gun and confront Ahuja. Nanavati was sentenced to life imprisonment but later pardoned by the Governor of Bombay. This decision underscored the judiciary's role in ensuring justice despite public opinion. So the main keyword here is that the Bombay High Court overturned the jury's acquittal, convicting Nanavati of culpable homicide not amounting to murder. So earlier there was a murder charge, but he was released by the jury. But later the High Court overturned the verdict, and Nanavati was convicted of culpable homicide not amounting to murder, so which carries a sentence of 10 years and imprisonment. Next, how did the Nanavati trial influence criminal jurisprudence in India? The trial influenced criminal jurisprudence in several ways. First, the abolition of the jury trial. It highlighted the need for impartial adjudication free from public bias. It set the benchmarks for proving what is grave and sudden provocation, requiring immediacy and lack of premeditation. That is, that action should have happened immediately on its own will or during that circumstances, and there should be no premeditation or thought of killing or of murdering. Media ethics. It prompted discussions on the responsible reporting of sensitive cases. These developments continue to shape modern criminal law practices. That is why this is considered as a landmark, one of the landmark cases. Next, what lessons can be learned from the Nanavati trial about justice and morality? The key lessons include separation of emotion and law. That is, justice must be based on evidence, not emotional narratives. The role of the judges versus the juries. Judges are better equipped to apply legal principles objectively, and public sentiment. While public opinion may sway perceptions, courts may remain insulated from external pressures. For example, the Nanavati case reminds us that moral outrage should not override legal reasoning. Next, how does the Nanavati trial remain relevant in contemporary legal discourse? The Nanavati trial remains relevant today also because there are media trials, which means modern cases often face similar challenges with media sensationalism influencing public perception. Sorry, I'm not able to pronounce this word. Next is provocation defense. Debates persist about its applicability in domestic violence and honor killing. Judicial reforms. The case underscores the importance of impartial adjudication and procedural fairness. So, three things: media trials, provocation defense, and judicial reforms. This is why it is still relevant in modern legal discourse. For instance, recent high profile cases involving celebrities or politicians echo concerns about media bias and judicial independence seen in Nanavati's trial. Next is the case law of Derek Chauvin trial and why it gained global attention. The Derek Chauvin trial involved the prosecution of a former Minneapolis police officer for the murder of George Floyd on May 25, 2020. The case gained global attention due to the graphic video of Floyd's death, which sparked widespread protests against police brutality and systemic racism. Its role in igniting the Black Lives Matter (BLM) movement globally. The legal outcome being seen as a test of accountability for law enforcement officers. So, three things. There was a graphic video evidence. Second, it led to Black Lives Matter movement. And third, uh, it there was a greater accountability. There was a demand for greater accountability for law enforcement officers. So this was the why it gained greater attention. Chauvin was convicted of second-degree unintentional murder, then third-degree murder, and second-degree manslaughter. We'll need to understand all of these three terms for a separate video. We'll do all of these, not here. What were the key facts of the George Floyd case? Key facts include the incident, that is, Derek Chauvin knelt on George Floyd's neck for over 9 minutes during an arrest for allegedly using a counterfeit $20 bill only. Victim's plea: Floyd repeatedly said, "I can't breathe," while bystanders pleaded with Chauvin to stop. Medical cause of death: the coroner ruled Floyd's death a homicide caused by cardiopulmonary arrest, that is almost like a heart attack, complicating law enforcement subdual. Defense argument was that Chauvin's lawyers claimed Floyd's pre-existing health conditions and drug use contributed to his death. These facts formed the basis of the prosecution's argument that Chauvin's actions were excessive and unjustified. What charges were brought against Derek and what do they mean? Derek faced 3 charges. Second-degree unintentional murder, which means causing death without any intent while committing or attempting to commit a felony. Felony is a murder rule. Felony murder rule. Third-degree murder means causing death through a dangerous act without regard for human life. And second-degree manslaughter means causing death through culpable negligence. Each charge reflected different degrees of intent and recklessness, ensuring multiple avenues for conviction. So second-degree murder means causing death without intent while committing or attempting to commit a felony. Third-degree murder means causing death through a dangerous act without regard to human life. Second-degree manslaughter means causing death through culpable negligence. How did the prosecution build its case against Chauvin? The prosecution relied on video evidence, experts' testimony, police protocols, and witness accounts. Let's go one by one. Video evidence: footage from bystanders and police body cameras showing Chauvin kneeling on Floyd's neck. Expert testimony: medical experts testified that Floyd died due to asphyxiation caused by sustained pressure on his neck and back. That is, he was not able to breathe. Police protocols: law enforcement witnesses stated that, that is, the fellow police officers, that Derek violated training guidelines on the use of force. And the witness and the bystanders described Floyd's distress and Derek's indifference. This multifaceted approach established both causation, the cause, and the culpability. What arguments did the defense present during the trial? The defense argued, so one part is the prosecution, the other part is the defense. The defense argued, the defense is from Derek's side. The prosecution is from George Floyd's side. Pre-existing conditions. The defense took this argument that Floyd had a heart disease and he was also using drug, which were some of the few contributing factors to his death. Carbon monoxide poisoning. The defense suggested that the car exhaust, which was nearby the scene, could have also played a role in carbon monoxide poisoning. They said that the car's exhaust may have killed him. There was resistance by Floyd. He also claimed that Floyd resisted arrest, justifying the use of force. But when one sees the video of this incident, one can see that George Floyd's hands were tied behind his back, and there was no way he could have resisted other than for breathing. Lack of intent. The defense argued that Derek did not intend, that there was no intention to kill Floyd, and his act is to be perceived within the limits of his authority, that as a police officer, he was acting within the limit of his authority. However, these arguments were largely discredited, were discarded by expert testimony, that is his fellow officers, and the evidence, that is the video recording evidence. Next, what was jury's verdict and what did it signify? The jury found Derek Chauvin guilty on all counts. The second degree unintentional murder, that means there was a murder but there was no intention, culpable homicide not amounting to murder. Third degree murder, second degree manslaughter. The verdict signified a rare instance of holding a police officer as accountable for excessive force. It was a symbolic victory for the Black Lives Matter movement and also advocating for police reform. Recognition of systemic issues in policing and racial injustice. It reinforced public trust in the judicial system's ability to address high-profile cases fairly. How did the trial address issues of systemic racism and police accountability? The trial highlighted systemic issues, that is racial bias, police culture, and legal precedent. Historically, these patterns of disproportionate violence against black individuals by law enforcement was clearly seen, that the police officers or white police officers used to target black citizens or black individuals. Questions about blue wall of silence and reluctance to hold officers accountable. This blue wall of silence means it represents the police officers' silence. What is the culture in police? That they would support their fellow officers or their friends in the police. So there is this question of what is happening within the police, and the police officers should be held accountable. Legal precedents. This incident demonstrated the need for clearer standards on the amount of force or the use of force and the accountability mechanisms. While the verdict addressed individual accountability, the broader reforms remain a work in progress. What role did public opinion and protests play in the trial? Public opinion and protests influenced the trial indirectly. That is, global pressure. Mass demonstrations kept the case in the spotlight, ensuring transparency and fairness. Judicial awareness. Judges and jurors were likely mindful of the societal implications of their decisions. Policy changes. The trial accelerated discussions on police reform, including bans on chokeholds, that is, holding through the neck, and increased accountability measures. However, the court emphasized that the verdict was based solely on evidence, not external pressures. What lessons can be learned from Derek Chauvin's trial? Key lessons include accountability in policing, that is, officers must be held responsible for misconduct to restore public trust. This is a very good policy in the US which is not enforceable in India. Use of force policies. Clear guidelines are needed to prevent excessive force and ensure de escalation. Systemic reforms. Addressing racial bias requires comprehensive changes in law enforcement training and practices. Importance of evidence. Video footage played a crucial role in securing justice, highlighting the need for transparency in policing. For example, the trial underscored the importance of body cameras and independent investigations. Next, how does the Derek Chauvin trial impact future cases involving police misconduct? The trial sets important precedents. First is prosecutorial willingness. It encourages prosecutors to pursue charges against officers in similar cases. That is, the state itself is prosecuting its officers. So that willingness has to be there. Normally, it does not happen. Public scrutiny increases awareness and demand for accountability in law enforcement. This trial also set some legal standards. It reinforced the importance of adhering to constitutional rights and professional ethics. Future cases may see greater emphasis on evidence collection, expert testimony, and community involvement in addressing police misconduct. What are the main divisions of law? The law is broadly divided into two categories: public law and private law. Public law governs relationship between individuals and the state, that is the public law. It includes constitutional law, administrative law, and criminal law. Constitutional law defines the structure, powers, and functions of the government institutions. Administrative law regulates administrative agencies and their action. And criminal law addresses offenses against the society or the state. Example, theft, murder. Let's look at the private law. Private law governs relationship between individuals or organizations. It includes contract law, which governs agreements between parties, tort law, which addresses civil wrongs causing harm or loss, example, negligence. Third is the property law, which regulates ownership and use of property, and family law, which covers marriage, divorce, adoption, and child custody. These divisions help organize legal principles and provide a framework for addressing disputes. So, these are the two different types in which the divisions of law, basically public law and private law. How does understanding the divisions of law aid legal practitioners? Understanding the divisions of law helps legal practitioners by identifying the appropriate area of law applicable to a case. That is, as a lawyer, we should know whether we fall under public law or private law. Navigate statutes. Then after that, we can find out which statute, regulation, or precedents are relevant to our case. Thereafter, we can develop strategies tailored to the specific legal context. For example, distinguishing between criminal and civil law ensures the correct procedures and remedies that we have to pursue. Next, what is the case law technique and why is it important? Case law technique involves, as a lawyer, analyzing judicial decisions, that is the past decisions of the courts, to understand the legal principles. It is important, the case law technique is important because It ensures consistency and predictability in the legal system through precedent. We can be assured that if our case is very relatable to a precedent, then we can expect some kind of consistency or predictability in the outcome of our case. It allows lawyers, advocates to build arguments based on past rulings, and therefore we can build our case based on those past rulings. It provides guidance for interpreting statutes. We'll be able to understand and interpret statutes and resolve any ambiguities. Key components of the case law technique involves or includes identifying the ratio decidendi, that is binding principle, and distinguishing it from the obiter dicta, that is the non-binding observation. So we have two, ratio decidendi and obiter dicta. How do courts use precedent in the case law techniques? Courts use precedent under the doctrine of stare decisis, that is to stand by things decided. This is precedent. Lower courts must follow higher court decisions on similar issues. Precedents ensure uniformity in applying laws and reduce arbitrary outcomes. Judges may distinguish cases on unique facts to avoid applying precedents. For example, the ruling in Donahue versus Stevenson in 1932 established the modern concept of negligence which lower courts consistently apply. So let's go through this question again. It's an important question. How do courts use precedent in case law technique? So courts follow the doctrine of stare decisis, that is to stand by things decided, that is to follow the past judgments. Now, all lower courts have to follow the decision of the higher court, that is the session court will have to follow all past judgments of the high courts or the decisions on similar issues. Now, these precedents, if utilized, they ensure that there is uniformity in application of laws. That is, laws are uniformly applied, and therefore it reduces arbitrary decisions. Now, if judges want to avoid applying precedent, then they will look at the distinguishing case or the unique facts of each case and therefore bypass precedent. What challenges arise in applying the case law technique? As a lawyers, as an advocates, we have to understand this also. So the main challenges in applying precedent in the case law technique is that there could be conflicting precedents, that there could be two precedents, two judgments of the past or more than two judgments which could be in conflicting nature. Now different courts may issue contradictory rulings, creating confusion. So there utilizing precedent would be more difficult. Outdated precedents. Certain precedents are overruled. So older decisions may not align with modern societal values or technological advancements. So there the use of precedent won't help. Wouldn't be of any help to an advocate. Now, lawyers must carefully analyze whether the precedent applies to the current case's facts. That is, whether the facts of the current case can be applied to the past cases. If they match it perfectly, then it can be used. So that is one of the distinguishing facts. So we have to understand whether our facts match with the past cases or past outcomes. For instance, digital privacy cases often require reinterpreting traditional taught principles to address new technologies. What is statutory interpretation and why is it necessary? Statutory interpretation involves determining the meaning and intent of a statute. Statutory interpretation involves determining the meaning and intent of a statute. Okay. It is necessary because laws are written in broad terms and may have ambiguity. Courts must resolve disputes about how a statute applies to a specific situation. So this is statutory interpretation by the courts. Interpretation ensures laws remain relevant amid changing societal contexts. Techniques like literal rule, golden rule, mischief rule guide judges in interpreting statutes fairly. So this is also a very important question. What is statutory interpretation and why is it necessary? So that any ambiguity in the laws can be addressed. One. Now, courts will interpret laws to understand that each specific situations may require different kind of interpretation, and interpreting ensures that laws are relevant to the current societal needs. What are the key rules of statutory interpretation discussed? Key rules include literal rule, golden rule, mischief rule, and purposive approach. This is also a very important question. Let's move on to the next question. What are the key rules of statutory interpretations? Key rules include literal rule, that is, words are interpreted based on their plain ordinary meaning unless absurdity arises or ambiguity arises. This is the literal rule. This question may come for the exams. Second is golden rule. Allows modification of the literal rule to avoid irrational outcomes. So this is golden rule is the modification of the literal rule. Then there is this mischief rule. Mischief rule focuses on identifying the problem that the statute seeks to address and interpreting it accordingly. And purposive approach, that is, the judiciary considers the broader purpose of the legislation rather than just the text or the law. For example, in Rajasthan State Road Transport Corporation versus Bal Mukund Bairwa 2009, the Supreme Court used the purposive approach to interpret provisions favoring accident victims. Next question. How do external aids assist in statutory interpretations? There are internal aids and external aids. So we'll look at only the external aids right now. Aids are basically helpers in a way. So external aids provide context beyond the statute's text. So if one has to understand what the law is trying to say or what it is trying to mean, then these external and internal aids help us do that. One is legislative history. So debates, committee reports, and drafts that reveal lawmakers' intent. So if some laws are ambiguous or not very clear, then we can look at the debates of the legislative or look at the committee reports before the laws were passed, or look at some of the drafts which were relevant to passing of those laws. Next is international conventions. We can compare the statutes or the laws with the international laws or how it is utilized or used abroad, outside India, for example. Treaties or global standards influence domestic laws. So we can take help of this external aid as well. Then we can also refer to the definitions of the words used in the statute with the literal definition, that is through the definition used in dictionaries. Also, We can use past judicial precedents, that is the prior interpretations of the similar statutes, that is how the laws or the statutes are used in prior cases, how it was interpreted. For instance, the Indian judiciary often refers to parliamentary debates to clarify ambiguous terms. Next, what role does the purposive approach play in modern statutory interpretations? Purposive means what was the purpose of bringing the law. That is what is meant by purposive approach. So here we are trying to understand the purpose of the legislative behind bringing this law. Not what the law is, but the purpose of that law, why it came in the first place. So the purposive approach emphasizes the broader objectives of the legislation. What was the objective, the aim of the legislation in bringing those statutes, those laws, rather than the rigid textual analysis, just not going by the words of the law, but rather understand the objective behind getting those laws. So in this purposive approach, what we are looking at is ensuring that the laws adapt to contemporary needs. Contemporary needs means the modern needs, so that the laws are adaptable to the modern requirements of the society. The purposive approach also tries to address gaps or ambiguities in drafting. When we understand what was the purpose of bringing the law or the statute to come into effect, we are trying to address ambiguities, differences, and gaps in the drafting and the actual law, or in our drafting also. Purposive approach also promotes justice and fairness over technicalities. The fairness of the law means that one is not only concerned about the procedure, but also the due process to be followed. The technicalities, we are not just concerned with technicalities. The court looks beyond the words, beyond the technicalities, to promote justice and fairness. For example, environmental laws are often interpreted purposively to prioritize sustainability over narrow readings. That is, environmental laws are broader in nature. They are not narrow. They will not just focus on the words of the statute, but they will try to understand the purpose of bringing those laws. Next, how do statutory interpretation techniques balance flexibility and certainty? Now, what is statutory interpretation? This is the interpretation of the legislature, that is, laws brought about by legislative. Now, statutory interpretation balances flexibility and certainty. So, how is flexibility achieved? By techniques like purposive approach, allowing laws to evolve with societal changes. When statutory interpretation is done, we know that interpretation can be done via purposive technique. Certainty. Rules like the literal rule, golden rule, and so on ensure that there is a predictable application of statutes, means there is a consistency in how these statutes are applied case after case. Judicial discretion. Judges exercise reasoned judgment to harmonize competing interests. For instance, tax laws require precise interpretation to prevent evasion while allowing adaptation to economic shifts. How can students effectively learn and apply case law techniques and statutory interpretations? So we can improve our skills by reading judgments, practicing problem solving, using study aids, and engaging in discussions. First, reading judgments. Students can analyze landmark cases to understand reasoning or what was the reasoning behind it and what precedent it gave. We can practice problem solving, that is, applying interpretation rules to hypothetical scenarios. We can use in our study referring to commentaries, textbooks, and online resources for clarity. We can refer to different study aids. Now, case laws helps in engaging in discussions. So participating in moot courts or study groups to explore different perspectives of the case law. For example, practicing how to distinguish facts in Kesavananda Bharati versus State of Kerala enhances understanding of constitutional law. Why is discipline considered essential in the study and practice of law? Discipline is foundational to the study and practice of law because it brings about accuracy, ethics, consistency, and time management. Accuracy means that we ensure precision in drafting our documents, in analyzing the cases, and applying laws. That is accuracy. Ethics means that we uphold professional integrity. We don't involve in misconduct or we maintain public trust. That is the ethics. Consistency means that we adhere to rules and procedures which foster fairness and predictability in legal outcomes. Time management means meeting deadlines for filings, hearings, and research is critical in a fast-paced profession. For example, disciplined preparation ensures lawyers present well-reasoned arguments during trials or negotiations. Next, how does discipline contribute to effective advocacy? Discipline enhances advocacy by thorough preparation, logical structuring, professionalism, and avoiding misconduct. All of these questions are very important for our law practice. Thoroughly preparing ourselves. First, ensure all facts, evidence, and legal precedents are meticulously reviewed. Go over it again and again. Understand how to prepare for all your facts, gather all your facts, evidences, and legal precedents, and review it thoroughly. Next is logical structuring, that is, presenting our arguments coherently, clearly, and persuasively, that is, with persuading nature to judges or opposing counsel. Our arguments should be clear and precise. Professionalism, maintaining composure, respect, and decorum during proceedings. Avoiding misconduct, refraining from unethical practices like misleading the court or withholding evidence. For instance, disciplined advocates anticipate counter arguments and prepare robust responses, strengthening their case. What role does discipline play in legal research and writing? Discipline ensures quality in legal research and writing by attention to details, organized analysis, clarity and precision, and proofreading. All of this is very important in legal research. Quality is more than quantity. Quality is required more than the quantity. Attention to details. First, identifying relevant statutes, case laws, and regulations without any oversight. That is, we have to understand which statutes or case laws are applicable to our case, to our matter. Then, to structure arguments logically and supporting them with authoritative sources. What is most important is in this is that the supporting facts, evidences needs to be there to support our arguments. Clarity and precision, using concise language, clear language to avoid ambiguity and misinterpretation, that is, to avoid confusion. And finally, proofreading, eliminating errors that could undermine credibility. So, after understanding or drafting, one has to reread or proofread the entire document multiple times to remove out or to eliminate any errors in the document. For example, disciplined legal writing avoids jargons and ensures compliance with citation standards like Blue Book or OSCOLA. How does discipline help in maintaining ethical standards in legal profession? Discipline ensures adherence to ethical standards. First, by conflict avoidance, second, by confidentiality, third, by honesty, and fourth, by accountability. Let's look at each one of them. This is when one adheres to the ethical standards of the law. So, ethical means to not use unlawful ways. Conflict avoidance, preventing situations where personal interests conflict with client representation. If such a situation arises, one should avoid taking up cases where your own personal interests are there which are conflicting with your clients. Confidentiality, safeguarding sensitive information shared by your clients. That is the responsibility of the lawyers to keep safe all the information that the client has given to the advocate. Honesty, providing truthful representation to the court, clients, and other stakeholders. Not to indulge in lies, to provide truthful representations to courts, clients, and not to hide facts, evidences from the court. Accountability, accepting responsibility for actions and rectifying mistakes promptly. For instance, disciplined lawyers avoid overbilling clients or engaging in frivolous litigations, that is, unnecessary litigations. What challenges arise in maintaining discipline in legal profession? First is the workload pressure. Second is the client demands. Third is technological distractions. Fourth is competitive environment. Let's look at each one of them. Balancing multiple cases with tight deadlines can lead to burnout or shortcuts. This is very common with most of the practicing lawyers, that they are handling multiple cases and the dates are very closely arranged, so that it becomes very difficult for them to concentrate on any one or concentrate correctly on one case or prepare for multiple cases on the same day. So this will lead out to burnout or taking shortcuts or taking adjournments. Client demands, managing unrealistic expectations while upholding ethical obligations. All clients would want to win, nobody wants to lose, and that expectations has to be balanced out by the advocate. Technological distractions, over reliance on digital tools may reduce focus on core tasks. Competitive environment, the pressure to outperform peers can compromise ethical behavior. This is very common, that the lawyers and advocates indulge in unethical behavior. For example, lawyers may struggle to maintain discipline when juggling family responsibilities alongside demanding caseloads. How can law students cultivate discipline early in their career? Law students can cultivate discipline by setting goals, creating routines, seeking feedback, and participating in moot courts. Setting goals. Establish clear objectives for academic performance and skill development. This is very important for all of us, that we have to set goals, that we want to develop these skill sets of argument, of speech or public speaking, and so on. So these are very important objectives that we can set as students when we are studying law for 5 years, and improve on uh, our argument skills, our logical thinking, analytical thinking, and so on. How to present ourselves, all of these will matter when we actually present ourselves or fight a case for our clients. Creating routines. This is also useful for our academic performance as well, not just our future practice. Creating routines, allocating specific times for studying, research, and extracurricular activities. All of these are important. Just studying is not enough. One has to do research, read case laws, go to different courts, see how lawyers argue, and so on. This, or maybe in our vacation time, we can do internship with in an advocate's office and see how things work out, or read up on different case laws, landmark case laws, and so on. Seeking feedback, regularly consulting professors or mentors to improve weaknesses, and participating in moot courts. Practicing oral, very important, practicing oral and written advocacy, both are important. Not only how to speak, but how to write, draft documents. Practicing oral and written advocacy under structured conditions, that is, under a set environment, like as in a court. For example, consistently preparing case briefs helps students develop analytical rigor and attention to details, which is also very one of the important part. The word detailed, understanding and paying attention to details. So when your client presents you with facts, figures, evidence, those details, attention needs to be paid to those details, and accordingly the drafting will happen. Also proofreading those documents and all of that. So one should start early, in the first year only, reading all the case laws and everything. How does discipline impact courtroom behavior? All of these case laws are available online, and one can easily search through them and read as many of them as possible to understand how precedents are applied to, to the case laws. How does discipline impact courtroom behavior? 1. Respectful conduct, preparedness, focus, and adherence to rules. All of these are very important when one presents themselves in the court. So, respectful conduct, addressing judges, opposing counsels, and witnesses courteously. Preparedness, arriving with all necessary documents, evidence, and arguments ready. Focus, avoiding distractions and staying attentive throughout proceedings, which is very important. Adherence to rules, following procedural guidelines strictly to avoid contempt charges, not to speak or not to interrupt the judge when, if the judge is asking a question, to reply, because we are the officers of the court. We have to help the court in, help the judge in coming to, or coming to a conclusion. For instance, disciplined lawyers file motions and objections timely, ensuring smooth proceedings. So all of these are very important for our future practice, as well as even in our academics. These are all very important, because when we are addressing our professors or our fellow students, there has to be a courteous. We can practice to address them courteously. We need to go to our class with all necessary books, papers, and maybe study in advance the topics that are going to be conducted in the class. So that is preparedness. Then not to be distracted in the class. That is staying attentive throughout our class time, maybe all class times. So that also will help us to improve our and prepare for our exams. Adherence to rules, that is follow the college and class rules to avoid being disqualified from the class or being told to get out of the class. So what are the consequences of lacking discipline in a legal profession? What happens if you lack discipline in legal profession? First of all, professional sanctions. Disciplinary actions by the bar councils for misconduct or negligence. The Bar Council of India can take, Bar Council of Maharashtra or of Bombay can take disciplinary action against the lawyers for any kind of misconduct or negligence complaints received by them. Then there could be a reputation damage, loss of client trust, or referrals. Referrals are very important in building up our practice, which could directly impact on the performance. Legal penalties, liability for malpractices claims. The client can claim claim liability for malpractice or unethical conduct. Career setbacks, missed opportunities for promotions or partnerships in firms. All of these can be consequences of not maintaining discipline in our legal profession. For example, failing to meet filing deadlines may result in case dismissal or adverse judgments. That is, orders coming against the client's favor, in client's favor. How does technology influence discipline in modern legal practice? Technology influences discipline both positively and negatively. Positive impacts. Tools like legal research databases, example Westlaw, LexisNexis, these are very famous and very widely used research database tools. These are paid ones. There may be a free edition also with limited options available. And these tools, they enhance efficiency and accuracy in our research. So if you're researching for our client, then we can take help of these tools which are available online. What are the negative impact of depending on technology? Over dependence on automation may lead to complacency or errors. Cybersecurity risk. Ensuring data protection requires disciplined adherence to protocols, which is very, very important, the third one, because the client is trusting us with their documents, and if it is leaked, somehow it is hacked, the computer is hacked, that could compromise the data integrity of the client's document. For instance, disciplined use of e-filing systems prevents technical glitches during submissions. What strategies can practicing lawyer adapt to maintain discipline? Practicing lawyers can adapt these strategies, which are prioritization, time blocking, continuous learning, and mindfulness practices. Focusing on urgent tasks while delegating less critical ones. Time blocking, allocating specific hours for client meetings, research, and court appearances. Continuous learning, staying updated on legal developments through workshops and courses. Mindfulness practices, incorporating stress management techniques like meditation or exercise. For example, setting aside mornings for focused work and afternoons for client interactions creates a balanced routine. This is a very practical question that they have asked. What is a moot court and how does it simulate real legal practice? Even if the above question does not come in the exam, it is still relevant for our law profession as and when we do our practice in the future. What is a moot court and how does it simulate real legal practice? A moot court is an academic exercise where participants argue hypothetical legal issues in a simulated courtroom settings. It simulates real legal practice by oral advocacy. That is, oral advocacy means participants present arguments before judges, mimicking appellate advocacy. that is, mimicking or reflecting actual advocacy in a court. Legal research. The moot court argument requires thorough analysis of statutes, case laws, and precedents. If one participates in moot courts, then it will also help in drafting skills. That is, the student will be preparing written submissions, which is also known as memorials, which is akin or similar to drafting petitions or briefs. So this will improve drafting skills. Judicial scrutiny. Judges will ask probing questions, testing participants' knowledge and responsiveness. So this will help us be attentive and respond or prepare for counter arguments or for responding to the judge's queries. For example, moot courts often tackle constitutional, criminal, or international law issues, preparing students for real world litigation. This would also include civil laws. What is a moot problem and what are its key components? A moot problem is a fictional legal scenario designed for moot court competitions. Its key components include facts, issues, parties involved, relevant laws, and relief sought. Background. The facts means background details about the dispute. What is the dispute about? What are its facts? What are its evidence? What are the statements? Second is the issues. That is the legal questions that need resolution. What is the purpose of the petition? What is the purpose of coming to the court itself? These are the issues. This needs to be addressed. So one is looking for a resolution for addressing these problems. So issues are basically problems which needs solution or answers. So that is why we are approaching the court. Parties involved. So we can have appellant, respondent, and their respective arguments. Appellant means the one who is appealing, who is putting the petition. And respondent is the one who is on the other end, who is defending. Relevant laws, statutes, regulations, treaties applicable to the case. So we have to find out all of these, which are relevant laws for our case. Finally, the relief sought or the prayers, the remedy requested by the parties. What have we come to the court for, and what are we requesting now? For instance, a moot problem might involve environmental laws requiring participants to argue whether a government policy violates constitutional rights. How should one approach analyzing a moot problem? To analyze a moot problem effectively, identify key facts, spot legal issues, research thoroughly, organize your arguments, and anticipate counter-arguments. So let's look at each one of them. First, highlight the facts relevant to the legal issue. What is the issue and what are the relevant facts which are directly correlating to these issues? Next is to spot what are the legal issues. That is, determine the primary and secondary questions of law. What are we trying to seek or redress or address from our petition? Research thoroughly. Locate statutes, case laws, scholarly articles, supporting arguments, etc. Next, organize the argument. Structured, logically, point-wise, the arguments have to be set. We have to address both sides of the issue, not just one. You have to understand both sides. What kind of stand the other party would take. That also has to be considered. Anticipate counter arguments. Prepare responses to the opposing counsel's likely argument. Counsel is the advocate appearing for the other party. For example, identifying whether a precedent applies narrowly or broadly can shape your argument strategy. That is, how much of the past precedent or past case applies to our present case that we are working on. So according to that, it will have more strength or less strength in our argument. What is a memorial in a moot court and what are its essential components? So memorial is nothing but the written submission filed by the participant in a moot court competition. It's essential, basically it's a draft. So it includes table of content. This is how a lawyer in real life scenario would also present the case papers in the court. First, table of contents, then index of authorities, statement of jurisdiction, statement of facts, issues presented, summary of arguments, detailed arguments, and then finally prayer or relief sought. So first, table of content. Basically, it organizes sections for easy navigation. It's like our index of a textbook where page number, the topic, and if date, the date is mentioned, or the page number or serial number. So serial number, topic, and the page number. Then index of authorities. That is, it will consist of the cases that we are relying upon, the statutes, and other references that we have cited in the draft or in the petition or in our memorial. Next is the statement of jurisdiction. Third, we will establish that the court that we are approaching has the authority to hear the case. That has to be clearly established. That has to be shown that the court has the authority to hear the case, otherwise it will be straight away dismissed. Fourth, we have to present all the facts, the statement of facts. This is the summary of all relevant facts concisely, clearly. Fourth, issues presented. Now, we have to identify in the document what are the legal questions that we want to be addressed. What are the key questions that needs resolution? Next is the summary of the arguments. First, we have to summarize all relevant facts concisely, clearly, and in detail, and then we have to also summarize our arguments. That is, we have to understand that when we are arguing, we have to finally say what in broad. If we had argued for say 10 minutes, then within 30 seconds or 1 minute, what were we trying to argue, that we have to summarize, which considering or including the key points of our arguments. Detailed argument. Elaborate on each issue separately with supporting authorities. So first we have to summarize what we are going to argue about, and then elaborate or go into detail on each issue with supporting documents, evidence, facts, and so on. Finally, what prayer are we seeking? What relief are we seeking? So that specifies the remedy requested. For example, a well-drafted memorial ensures clarity and persuasiveness, guiding judges through complex arguments. These are all very, very practical questions. So even if they don't come in the exam, they will still be useful throughout our journey of advocacy. How do memorials differ from oral arguments in moot courts? Memorials and oral arguments. Memorials are nothing but written documents or written draft. So memorials and oral arguments is verbal presentation basically. So oral arguments differ in format and purpose. Of course, we know that. So memorials are written documents which are submitted before the hearing, and they provide detailed legal reasoning. The oral argument is basically a verbal presentation or a verbal argument during the moot. Focus on concise, persuasive delivery and responsiveness to judges' queries. While memorials allow time for thorough research, because we are getting a lot of time to write, research, and all of that. Oral arguments will test our quick thinking and adaptability. How quick we are in responding to or counter arguing or counter presenting the facts of the case or replying to the judge's query. What skills are developed through participating in moot courts? Moot courts help develop critical skills for legal practice. First, when we take or participate in moot court competitions, we will improve our research skills. Basically, we will have to identify and gather all relevant legal authorities. Authorities in this case means case laws, precedents, past case laws, or do more research and so on. This will help in our analytical thinking. Basically, once we start reading through case laws, we'll be breaking down complex issues into manageable arguments. So basically, when we read through case laws, there'll be many arguments, but now we have to find out core arguments and break it down into simple manageable arguments. Public speaking. When we participate in the moot court, it will help us to speak in front of fellow students, in front of the public, in front of the professors, and that will help us articulate or present our ideas very clearly and confidently under pressure. So this will definitely help us in public speaking. Teamwork. We have to collaborate with our co-counsel to strategize and divide tasks. So basically, our counsel would be our friends or fellow students with whom we will do research, read on case laws, and argue and counter argue on different points, statutes, and so on, the jurisdiction and all of that. So that will help us do a collaborating teamwork strategies, time management, meeting deadlines for research because research is extensive. So we have to meet deadlines for the moot court as far as drafting and rehearsals are also concerned. For example, responding to unexpected questions during oral arguments sharpens quick thinking abilities. This is very important. One should keep practicing and ask for different kind of counter arguments from the counsel or from our co-counsels. How can one prepare effectively for oral arguments in a moot court? To prepare effectively, know your memorial. Read your document thoroughly, multiple times. Be familiar with every aspect of your written submission. Whatever has been written has to be there for a purpose. Now practice the delivery. Rehearse arguments multiple times to ensure fluency and confidence, which is very important. To practice the delivery, speech, keep practicing. Anticipate questions. Prepare answers to potential queries from judges. Focus on the structure, how you will start your introduction, followed by presenting your arguments logically point-wise, and then finally concluding with a strong argument. Finally, seeking feedback. Practice in front of your peers, your friends, or your mentors to refine performance. Ask them for a feedback. For instance, practicing mock sessions helps participants remain calm during actual hearings. What role does teamwork play in moot court competitions? Teamwork is crucial because it helps in division of labor. Team members can specialize in researching specific issues or drafting sections. So basically, it is a division of work. Peer review. Colleagues provide feedback on arguments, improving quality. Smooth support system encourages collaboration and reduce stress during preparation. Complementary strengths combine diverse skills like writing, speaking, and analytical reasoning. For example, one team member may excel at legal research while another shines in oral advocacy. So depending on the skill level of our peer, we can decide who would present the case, who would do the research, who would do the drafting, and so on. How do judges evaluate participants in moot courts? Judges evaluate participants based on the knowledge of the content that they have presented in their memorial, the depth of the understanding of legal principles and authorities. How deep have you understood all of these legal principles? The ratio decidendi, obiter dicta, actus reus, and so on. It's not just the Latin maxim, but also the principles behind the statutes, the literal rule, the golden rule, and so on. The clarity of arguments. How logically structured and articulated are your points during the presentation? That is also one of the bases on which you are judged. Responsiveness, your ability to answer questions accurately and confidently. That shows that you're paying attention, you're mindful of what is happening. Persuasiveness, convincing delivery and use of evidence. How persuasive you are in presenting your evidence, your facts, how convincing your arguments are. All of that also is seen and by the judge, and you're judged according to that. Professionalism, adherence to courtroom etiquette and decorum. How well dressed you are, how presentable you are, and how do you approach how do you approach the judge? How do you approach your counsel, and your clients? For instance, judges appreciate participants who acknowledge weaknesses in their case but counter them skillfully. Next, what are the common pitfalls to avoid in moot courts? Common pitfalls include overloading arguments, that is, unnecessary arguments, or increasing the length of the argument. Presenting too many points dilutes focus. Prioritize key issues. That is, the most impactful arguments have to be presented first, and not to increase or give too many facts or for that argument. Present it as concisely as possible. Ignoring counter arguments, that is, not preparing for the counter arguments from the opposing counsel, that is, and the argument which will weaken basically our credibility because we are not prepared for the counter argument. Poor time management. Running out of time before completing submissions frustrates judges. Judges are also constrained for time. They have to go through multiple cases in a day, and there is very limited time for each case. So, not to unnecessarily extend or go beyond the time allocated for your arguments. So, in a very concise and clear, analytical manner, one should present their arguments. Lack of preparation. One has to go prepared. If one doesn't do that, then it shows that one does not have enough confidence or persuasiveness in their arguments. Disregarding etiquette. Interrupting judges or opposing counsel reflects poorly on professionalism. Till the judge has not completed what he wants to say, the lawyers should not interrupt them and listen to them thoroughly, what they are asking or what their query is, or whether they have acknowledged or not. And similar is for the opposing counsel. One should not interrupt when they are presenting their side. For example, rehearsing time allocation ensures all arguments are presented within allotted minutes. What is the constitutional basis for reservation in India? We are moving on to the next topic. Reservation in India is based on Article 15(4), 16(4), and 46 of the Constitution. Article 15(4) allows the state to make special provisions for socially and educationally backward classes. So this is for Article 15(4) for the socially and economically backward classes. Article 16.4 permits reservation in public employment for backward classes. This is important. Article 16.4. Article 46 directs the state to promote educational and economic interests of weaker sections, protecting them from social injustice. Article 46 is also important because this is the DPSP in the Constitution of India, where the state is directed to promote educational and economic and maintain or protect the economic interests of weaker sections. For example, reservations for scheduled castes, SCs, scheduled tribes, STs, and other backward classes, OBCs, aim to address historical inequalities. How does reservation promote social justice in India? Reservations promotes social justice by empowerment, by representation, by redressing inequalities, and by inclusive growth. Let's look at each one of them. Empowerment. Reservation provides access to education and employment opportunities for marginalized groups. That is, those groups which have been marginalized or not been able to come up due to multiple reasons in the society, whether they were poor or they did not have opportunities or whatever may be the case. But these are marginalized people. Representation, ensuring participation of underrepresented communities in governance and decision making. When the reservation takes place, basically it automatically ensures that people who are not represented or who are not able to easily represent themselves in the community because they don't have the resources, then representation helps in this matter.